Hello. We're going to start up, but we're going to do another real brief roll call just to make sure that we have quorum. So as we don't have quorum, we can't start up. Governor Abel.
Here.
Governor Adwale.
Here.
Governor Angeville.
Here.
Governor Boyd.
Here.
Governor Clark.
Here.
Governor Couch. Governor Dresden.
Here.
Governor Higginson.
Present.
Governor McBride.
Here.
Governor Peterson.
Not here.
Governor Siani.
Present.
Governor Stevens. Governor Williams-Reed.
Here.
Okay, we have,
Mr. President, I'm also here.
there you are. Okay, Governor Stevens, thank you. We have quorum. So we can begin. The first item on the afternoon agenda is the Washington State Bar Association Court Rules and Procedures Committee items. And we have Corinne Wilson here maybe on the virtual, yes?
Yes, that's correct.
There you are. Okay, well, thank you. The floor is
All right.
yours.
Well, thank you. I am here in place of Isham Rivas, who is in trial. I am the chair of Subcommittee X, which I am sad to say is not nearly as exciting as it sounds. Here to present a couple of issues on court rules. So the first issue I wanted to bring to your attention was with regard to Court Rule 5. We were invited to review Court Rule 5 with regard to mail delays. As you may know, Court Rule 5 stipulates that a 3-day time period is provided for service by mail. And according to the U.S. Postal Service, mail isn't being delivered in 3 days. It's normally a 5-day turnaround time. And so we were invited to discuss whether or not a change was appropriate given the change in timing. And what we determined was that changing Court Rule 5 is not going to solve the problem. It's a bigger problem than that. If we enlarge the time for service by mail under Court Rule 5, that has a domino effect on court deadlines, on filing deadlines. Some deadlines are shorter than 5 days, and so it creates more problems than it solves. And so we wanted to bring that report back to you folks to determine what best next steps to take. There's another issue with regard to the mental proceeding rules, and Andrew Van Winkle is here to present on that because he has much deeper knowledge on that issue than I do.
Thank you, Corinne. Andrew Van Winkle, Court Rules and Procedure Committee. My understanding is the Board of Governors got an inquiry on whether or not the mental proceeding rule should be updated in light of recent statutory amendments. There have been quite the overhaul over the last couple of legislative sessions. And I believe that the answer is yes, they do need some updating and probably just a good overhaul. For the most part, the rules haven't been updated since implemented in 1976. But to draw your attention to a couple of items that are now in conflict with the new statutes, Court Rule, Mental Proceeding Rule 1.2 governs continuances and postponements in mental health proceedings. There is now a new statute on point, RCW 7105-236, which is way more detailed than Court Rule 1.2. So we've got a conflict right there. And then going down just a little bit, Court Rule 1.4 deals with less restrictive alternative treatments. If a person is held, goes in for a mental health proceeding, the court can hold him for 14 days, 90 days, 180 days, depending upon where they are in the process. But they can also impose a less restrictive alternative treatment, basically outpatient treatment instead of inpatient treatment. Under Court Rule 1.4, less restrictive treatment is limited to the same number of days as the equivalent inpatient treatment. But if you look at RCW 7105-240, if someone is being held for 14-day inpatient treatment, the court has the option to instead do a 90-day less restrictive alternative now. So we now have RCW 7105-240, which is in direct conflict with NPR 1.4. So those are just a couple of the conflicts. We also have a lot of new terminology. Previously, mental health disorders and substance use disorders were treated separately. The RCW now has a new umbrella term for them, combining them both under the heading of behavioral health disorders. So there's also some housekeeping matters there in terms of terminology in addition to direct conflicts with the statute. So my recommendation would be for the Court Rules and Procedures Committee to form a subcommittee that would work with stakeholders to bring the MPRs in line with the current RCWs.
We do have questions. Good. Governor Williams-Ruth.
Thank you, Mr. President. So I want to clarify, since I'm the person who raised the issue regarding mailing. So we've received confirmation that mail is not being delivered in what was the generally accepted principle when I started practicing law 20 years ago, that was 3 days. But we're not actually looking at changing the rule that then requires people to give more notice and allow for more mailing for those who are there being served by mail, because there are some places that only have 5-day service windows. But so I'm confused. So it's like we've identified there is a problem, confirmed there's a problem, but we're not going to try and fix it. I'm confused.
No, that's I don't think that's an accurate summary. We've not refused to fix the problem. We've identified that the problem cannot be fixed by simply tweaking Court Rule 5. If we change Court Rule 5 to allow 5 days for service by mail in a situation, for example, where there is a reply due in 3 days or even in 5 days, then you have an instant turnaround that requires you to get your reply in the mail on the same day that you may have received the document that you're replying to. So it has a cascading effect on other court deadlines. There are multiple ways.
Hold on, I need to clarify, because it's been a while since I've been an active litigator. Wouldn't it be, if I've been served, I then have 5 days to type up my response and then I mail it, and that should be their time? I mean, so again, if it's not just going to be Court Rule 5, where do we fix the problem? I mean, if it's not just a CR5 change, what do we need to do to fix this issue?
Well, I think there's a couple of different approaches. We have not come up with the solution. I think what we're confounding here is a document may be due in shorter than a 5-day time frame to the opposing party. So you may not have 5 days to mail it. So if we enlarge the time for mailing to 5 days, then the people who are counting on mail are out of luck. That's the problem. So there are probably several different ways to deal with it. And we can definitely discuss those in committee. I can come up with ideas off the top of my head, which I don't know is really appropriate. We can change all of the deadlines under the court rules. We can create things on different tracks where people who are using service by mail have a set of deadlines. We can ask people to petition to serve by mail. We can assume by default that pro se's will just serve by mail. I mean, there's a lot of ways to approach it. We haven't come up with a solution for the entire problem. What we have determined, though, is that just changing Court Rule 5 isn't going to fix the issue.
Okay, and I guess I never, when I raised this issue internally within the board, I was never specifically saying it was going to just be a one thing. I just was pointing out that this is a larger issue of, again, access to justice, especially with our pro se litigants and those counties that don't have electronic service, or people who, for whatever reason, have not accepted into it. And so maybe the answer is going to be that we need to create specific rules and timelines for all motion practice or any of the deadlines for those who are not engaging in electronic service. I mean, and since we don't have a unified court system across all counties and jurisdictions, I'm just trying to look out from our level here at the Board of Governors, where we're policy setters, creating something that, again, has that lens of fairness and equity for all of the parties involved.
Oh, sure. Yeah, I don't think anybody denies that there's an access to justice issue, especially when you're dealing with people who are incarcerated and are trying to send things by mail. When you're dealing with, say someone who is represented, but is perhaps in a remote area, or is a person who either for financial reasons or maybe elderly, they don't have access to technology. So they're relying on, if, for example, they need to sign a declaration, they have to have their attorney mail it to them, and then they have to mail it back. And God forbid there be any revisions so that there's another round of mail. It's just, it's a much bigger problem than just saying, okay, we're going to change 3 to 5.
Any other questions for our presenters? Any real hands? Virtual hands? Not seeing any. I want to thank both of you for being here today and telling us what the problems are, and that you're going to probably be working on some suggested solutions.
Great. Thank you.
Thank you. Oh, we're a little early now. Oh, they asked for direction. That's right. I'm sorry. So let's open up for discussion to the committee, to the board to see if they've got any proposed guidance for the Court Rules Committee. Excuse me. Any questions? Any thoughts? Any proposals? Governor Couch.
I mean, I don't have a specific proposal on this, but I do think this work that has been done is good. And I think the problem still exists, and this should be explored further. And perhaps, perhaps a rule change is needed, but I'd be curious to see what proposal could come out of this group.
Governor Williams-Ruth.
So I'm curious if we should, if it's bigger than what was originally sent to court rules, because we thought that might be the answer for the solution, would it then need to go someplace else? Because again, if the Court Rules Committee is to be talking about court rules, and if the answer is going to not just be in the court rules, I mean, I'm curious if we need to reallocate to where it's going, or if the answer still is in the court rules, it's just going to be more than just the one, or again, and I am open to, suggestions from those who know how the system is modified and where the beginnings of a change have to occur. But it seems that we've confirmed there's a problem and that there's an issue that needs to be addressed, but now we're not sure where.
Governor Higginson.
Well, I wanted to say that I completely can understand why we're having the presentation that we are, because I doing litigation as one of the many things that I do. I can perceive the dilemma between enlarging the amount of days for service by mail, and then potentially delaying litigation responses as a result. Initially, I was definitely in favor of simply enlarging the time, as Governor Williams-Ruth had at least thrown out as an option when he first brought this up. And I still kind of think that might be a good idea, but I was wondering if we might have a bit of a discussion about as has been requested of us crafting a proposal increasing the time to respond to pleadings or paper served by mail. I mean, I could pick a number, 7 days or something like that, but I don't know if that's the right number of days. It does seem like that might be, on balance, it may be a good idea. On the other hand, I was reading an article recently, and I think it was the Wall Street Journal, about the Postal Service saying that costs are going to go up further and further next year because of various reasons. And I imagine that fewer and fewer people are actually going to be using mail. So I'm also wondering if we ought to be looking at something more for encouraging or even mandating electronic service, except for those people who don't use email. You know, as our presenter mentioned, you know, the elderly are sometimes people, and I don't want to sound in any way ageist, but it does seem like the very elderly who haven't really used email too much tend, or maybe they don't have access to a computer or something of that nature due to their financial circumstances. They need to be taken into consideration too. So I would be in favor of a further discussion on this. As far as the mental proceedings rules go, that seems, I was wondering if we might think about seeing if we could contact, I don't know who we is specifically, but I guess since I'm on the board, I would say the board, or we could maybe give some direction to the Court Rules and Procedures Committee to see if they might contact prosecutors, the Washington Association of Criminal Defense Lawyers, maybe the Attorney General's office, and whoever else might be interested stakeholders in mental proceedings rules to see if they have some initial feedback on changes that might be made. It seems like perhaps the health law section might have something to say about that, the older law section. And it may just be something that more information should be gathered, because if there's problems that need to be dealt with in that statute, we ought to be taking a look at that. So those are my comments, and I'm just wondering if anybody has any thoughts about that, or if Ms. Wilson might have some thoughts. Maybe this has already been talked about at the Court Rules and Procedures Committee, but I'd like to be of some support here in trying to get these things clarified, because they do look like both of these things are issues that we would be incumbent upon us to see what we could do to help move forward. So those are my thoughts.
Well, I can tell you that I reviewed every single set of local Superior Court rules to see if any county had either changed Court Rule 5 or made any specific provisions related to electronic service. I was not able to identify any county in which Court Rule 5 was changed to enlarge the time for service by mail. There were several counties where electronic service was required. For the reasons I pointed out, though, and this is just me interposing my experience and not necessarily speaking on as a committee decision, but for persons who are not able to access technology for whatever reasons, I hesitate to force electronic service on everyone, even though it's my preference. I just don't think that allows access to justice for everyone.
Mr. President, might I say something more here?
Have a follow-up question or comment?
Yes. Well, I just wanted to say I share that concern in terms of not making it more difficult for people with technology limitations or simply no access to them to be forced into this. And I have a client right now as an example who can't afford he cannot afford internet service, and so when he needs to receive things from me quickly, we have to go to a local office supply place, and I arrange to email it to them, and they print it out and give it to him. But then that increases the cost as well, though I usually pay for it because I just want him to have it more readily than mailing it. So I don't know. That's why I thought maybe there should be some additional discussion about this, so that we have the Court Rules Committee has some guidance on how to proceed. And so anyway, thank you, Ms. Wilson, for your comments. I certainly think they make sense. And my goodness, thank you. And it's really impressive you reviewed every single county's court rules, because that had to be mind-numbing.
Executive Director Nevitt, and then Andrew Van Winkle. Scott has hand too.
Why don't you go to Mr. Van Winkle first, because I suspect he wants to respond to Governor Higginson's question.
So two things that I'd like to respond to regarding the NPRs. I believe what the Court Rules and Procedures Committee would be looking for is a resolution from the Board of Governors asking the Court Rules and Procedures Committee to take up that issue, since it's not part of a regular review cycle. So we just are looking for something there instructing us to take a look into that if that's what the Board of Governors wants us to use our time on. Regarding the service, one thing that's a comment that I'd like to make is I think the Board of Governors, in talking about this, should also be cognizant of what's going on with unrepresented persons. Now, one of the big changes to come out of the legislature last year was an overhaul of the civil protection orders. One of the amendments that the legislature made is that civil protection orders and documents in civil protection order cases can now be served via email and social media, such as Facebook and other forms of social media. So electronic service and mandatory electronic service is now here and with us. The legislature has extended that in that limited realm. So it's something that perhaps we also need to be looking at changing rules to incorporate and deal with what the legislature's tossed in our lap.
Executive Director Nibbit and then Nancy Hawkins.
Thank you. I just wanted to, following up on one of the suggestions I heard, put the question back to Chair Wilson. Is it, having researched the issue of the mail delivery and started brainstorming some solutions, is it your impression that this, because I'm sort of generally hearing a sense that the board would like the issue to be explored further, is it your sense that it's become outside the scope or capacity of the Court Rules Committee, or if the board would like you to further pursue it, does the committee have the capacity to do that?
I think it's within the capacity of the committee to do it. It would just require more than an amendment to Civil Rule 5. So I don't think it's outside of our scope. And there's a number of different approaches that we could potentially take. It would just require more of a sweeping change to the court rules as a whole, rather than just to one single rule.
I believe Nancy Hawkins, you're next.
Thank you. First of all, Ms. Wilson, a heroic effort to both identify the problem and search for a solution which doesn't really seem to exist. But you've identified lots of problems, and I'm sure there's 100 more that can be identified that people are starting to raise. But the real problem is the Postal Service, and that is a federal government Postal Service issue that needs to be addressed. And at a minimum, the Bar Association, I would think, may want to consider sending a letter to our members of Congress, our senators, the president, the Postal Service itself, identifying the many problems that this investigation has shown, as well as some of these comments have demonstrated, so that maybe we can light a fire under the Postal Service, because frankly, it is embarrassing that in a country of our wealth and knowledge and abilities can send a Christmas present across the country overnight, but we can't get a letter 10 miles in under 5 to 10 days, it would seem. And so it's not a solution, but it's something in addition to continuing to identify problems and trying to patch together a solution. But, you know, let's get people working on this. I do not understand why things are getting worse with regard to the U.S. mail. It is something I think we can put some attention on. We can ask other states to do the same, and maybe that will get some attention in Congress.
Any other thoughts or comments or concerns? I don't know if we're going to be able to take any action today or even come up with a concept for a work group. What we could do is discuss this at our next executive committee meeting with the thought of maybe generating yet another task force that might be able to get a smaller focus group to work with the rules committee, possibly to come up with some possible solutions. But thank you for identifying that it's not just Court Rule 5 that we all have to worry about. It's really the overall structure of the court rules and their interface with the RCWs, which are got all sorts of filing things in them too. Anybody else have any questions or comments they want to make to our two presenters, Corrine Wilson and Mr. Van Winkle?
Mr. President, can I
Governor
just,
Higginson.
I think that it would be a nice thing for us to talk about this at the next executive committee meeting to see where we might want to head. It does sound like, as Tara indicated, there may be a general view here that we'd like to do something, but we haven't really fleshed out what that might be yet. So I just don't want I don't want the Court Rules Committee to think, at least from my standpoint, that we're just saying, thanks a lot, sorry you wasted your time, see you later. I mean, I want it to be clear that from my standpoint, I'm extremely grateful for what they've done. Being a busy attorney myself, I'm mindful of what it takes for you guys to do what you do and still keep your practices going. So I just want to say thank you. And I hope we will be able to talk at the next executive committee meeting about how we might proceed with a subcommittee or what have you. So.
Executive Director Nevitt.
A couple of things I just wanted to, I don't know, point out or clarify, or hopefully this will be a value add. The executive committee can certainly discuss the issue, but won't be able to take action on the issue unless the power has been delegated by the board, which means that it would maybe have to come back to the board in July. I also wanted to note that I'm not sure that it requires board action for the Court Rules Committee to continue the work on either of these topics. I think they're looking for feedback, which I think you've provided. So I would just offer that, you know, unless Ms. Wilson and Mr. Van Winkle disagree, I think they've gotten what they came for, which was feedback from the board. And if the board is happy for them to proceed, I'm not sure that any other action needs to occur. And certainly, if the board decided in July that it wanted to take additional action, it certainly could at that time.
Thank you for that clarification. And certainly by my comments, I wasn't suggesting that the executive committee was going to do anything other than have a better, there's going to be time to reflect between now and the next executive committee meeting, and somebody might come up with some ideas. And of course, any board member can show up at the executive committee meetings and share. So, okay, any other hands up or anything like that? Don't see any. Looking around the room here. Okay.